Hello and welcome back. I'm attorney Andrew Bethel of Bethel Law, where we talk estate planning, finances, real estate, and taxes. Today we're diving into California Assembly Bill 1483 and how it impacts firearm purchases, particularly in the context of estate planning and probate. This is a critical topic for anyone involved in trust and probate administration, especially when firearms are part of the estate. So hit like, subscribe, share the video with anyone navigating probate or a trust, and let's dive in. CA Assembly Bill 1483 aims to enhance the safety and regulations of firearm sales in California by addressing the safety and regulation of firearm sales in specific issues related to the sale and transfer of firearms. One of the primary goals of AB 1483 is to tighten the requirements for obtaining and maintaining a firearm dealer's license, ensuring that all employees undergo thorough background checks and that retail locations have enhanced security measures. Additionally, the bill mandates that firearm dealers report all sales and transactions to the Department of Justice, DOJ, providing detailed information about the buyer, the firearm, and the transaction. AB 1483 also reinforces the mandatory waiting period for firearm purchases and ensures that comprehensive background checks are conducted before a firearm can be transferred to the buyer, which we'll come back to. This aims to close any loopholes that could allow individuals prohibited from owning firearms to acquire them. Dealers are also required to maintain comprehensive records of all firearm transactions, which are subject to inspection by law enforcement agencies to improve traceability and accountability. Furthermore, the bill introduces stricter regulations for private party transfers of firearms, requiring those transfers to be processed through licensed dealers who will conduct the necessary background checks and record keeping. However, one of the significant amendments introduced by AB 1483 relates to Penal Code Section 27535. Under the current law, a person is prohibited from making more than one application to purchase a handgun within any 30-day period. AB 1483 amends this section to exempt from this prohibition any private party transaction where the seller is transferring firearms due to the death of the owner of the firearm. This amendment is set to take effect on January 1st, 2025. The amendment to the Penal Code has several important implications for estate planning and probate. Firstly, it provides relief for trustees, executors, administrators, and beneficiaries who need to transfer firearms as a part of settling an estate. This exemption helps avoid the 30-day limit on handgun purchases when dealing with multiple firearms from a decedent's estate. During the probate process, executors and administrators must accurately inventory all firearms in the decedent's possession. Proper documentation and valuation of these firearms are necessary for estate planning and probate process in particular. Executors must also ensure the legal transfer of firearms to heirs or beneficiaries comply with both federal and state laws. This includes conducting necessary background checks and processing transactions through licensed dealers when required. Additionally, firearms must be securely stored during the probate process to prevent unauthorized access or potential misuse. Of course, beneficiaries must be eligible to own firearms under federal and state law. The transfer of firearms to ineligible persons can result in legal complications and potential liabilities for the estate. And while this holds true for a trust administration as well, I emphasize probate here because due to the nature of probate, we'll have a court overseeing the entire process. So we really need to dot our I's and cross our T's. A trust administration, by its nature, is a private affair. We must comply with federal and state law, of course, but there won't be a judge looking over your shoulder each step of the process. To fully understand AB 1483 in the context of estate planning and probate, it's helpful to remember some of the historical and practical considerations. California has stringent firearm regulations, of course, aimed at reducing gun violence, and the one handgun per 30-day rule is a part of these broader efforts. When drafting your estate plan, we'll need to keep in mind what's required to address some firearms: proper documentation, secure storage, and clear instructions and understandings for your executor or successor trustee. Trustees, executors, and beneficiaries must navigate both federal and state law governing firearm transfers. The Gun Control Act of 1968 and the National Firearms Act imposes additional requirements and restrictions. Even with the exemption provided by AB 1483, some transactions may still require processing through licensed firearm dealers to ensure compliance with all legal requirements. Now, today's video was meant as a short primer to a broader discussion on firearm inheritance in California, so be sure you're subscribed and you've rung the bell to be notified when that video goes live. For now, I wanted to discuss AB 1483 since it directly speaks to administering an estate and the changes go into effect at the start of the new year. To summarize, CA Assembly Bill 1483 introduces an important amendment to Penal Code Section 27535, providing an exemption for private party transactions involving the transfer of firearms due to the death of the owner. This amendment, effective January 1st, 2025, has big implications for estate planning and probate cases in California. In essence, at the death of the firearm owner, soon will no longer be bound by the 1 handgun per 30-day rule, which will allow trustees, executors, administrators, and beneficiaries to offload those firearms from an estate in a more timely fashion. But let me know what you think. Have you had to deal with transferring firearms as a part of a trust or probate? What fun red tape did you run into? Let me know in the comments below. Thank you for watching. Be sure to like, subscribe, and share the video with that person in your family with more guns than kids. I'm attorney Andrew Bethel, and I'll see you at our next meeting.